this afternoon. As George said, I'm Secretary General of ICSID, and ICSID is the world's premier institution for doing investor-state dispute settlement. So it's done more than 70% of all known cases. So we have real expertise in this matter. What I wanted to do this morning is to give you a sense of what ICSID is and what the process of arbitration is at ICSID, and then to close with a number of statistics, which are probably more of interest. And I will go through those quickly because I will provide you with the PowerPoint later so you can look at them yourselves. But I think they're actually, I think, very optimistic statistics and show really good developments commensurate with your recent reforms. So I congratulate that. If we go to the first slide, I wanted to talk about, and I just say, I cannot see the slides, so thank you. Gulmira is kindly taking care of it, thank you. I wanna go through quickly an overview of ICSID on slide 2. Essentially, ICSID was begun in 1966 because states realized there were special needs when a foreign investor went to a host country and things went wrong. And it was frequently not able to go to the domestic system, or the domestic system did not offer equal access to justice. At the same time, there were a lot of barriers using international law, which in many respects had very, very strict requirements to have a state take your case on or espouse your case. And so there weren't a lot of viable options to try and do this kind of dispute settlement. And the result was this 1966 treaty where states got together and said, let's set up a truly international, impartial institution, and their job will be to have the facilities and the procedural rules to resolve these international disputes. And that basically was how ICSID was born. We have now done over, at this count, 830 cases over our history. And if we go to the next slide, you'll see that the mandate behind ICSID was that having this available to parties would help to attract and retain private investment. It would help to create stable investment climates, would help to support a rules-based international trade and investment system, and to depoliticize investment disputes. And of course, all of these are the kind of things that you are supporting through your justice reforms and your legal reforms. And that's all part of the picture of increasing investment into your country. If we can move now to the next slide. In order to do this, ICSID built a number of features into the system which really reflected what it was doing in terms of playing a role between a foreign investor having a dispute with the host state. The first thing was to allow individuals, and that could be people, regular people, or corporations, or juridical entities, to have direct recourse to arbitration. Before ICSID, you had a situation where you had to go to your home country and ask them to take on the case for you. And for many reasons, home countries did not want to do this. So this allowed the individual investor to bring a case directly to arbitration against a state. Secondly, there was a real effort to design a balanced system between investors and host states. And this continues to be an important thing in our current amendment process. Obviously, if parties feel it is not balanced, parties will not use it, and so you've defeated the purpose. Thirdly, something that's very important is that it is an autonomous or a self-contained system. And what that means is it does not ever get into the domestic courts of either the investor or the home state. And so neither party has to feel that they are litigating on the home turf of the other side, and they can be very confident that they are litigating in a truly international, non-political scenario. And there are a number of rules, including rules that an arbitrator cannot be a national of any of the parties, that you don't have recourse to state domestic courts. All of these are meant to build the confidence that this is a truly neutral place where the decision can be decided. There is also an enforcement mechanism which is key. It is a specialized and simplified enforcement mechanism. There is a high rate of voluntary compliance, which of course saves time and money. But most importantly, compared to the other option, which would be the New York Convention, once you have a final ICSID award, it gets certified and it should be presented to any jurisdiction where there are assets and automatically enforced. So there's no further review on the merits as there would be under the New York Convention system. And this is key because it really does cut out a lot of time and it makes this process much more attractive to everybody. So the simplified enforcement and generally enforcement itself is very, very important. And I'm sure as you've gone through your legal reforms, you're recognizing that the key to all of this, obviously, first and foremost, is prevention of any kind of suits. Secondly, good preparation. If you're into an arbitration or a mediation, good preparation. But thirdly, once all of the mechanisms have been exhausted, enforcement, and I think in many respects, letting the world know that the judgment has been complied with, because that really does build the reputation of a stable, predictable place to do your business, and if something goes wrong, to have a legal process. So those are the hallmarks of the ICSID system. If we go to the next slide, we are also well known as being a very cost-effective system. We'll go to the next slide, please. Perfect, thank you. It's cost effective. Obviously, it's done under the rubric of the World Bank. So we use World Bank facilities, and it is the only institution that can administer not just ICSID rules, but also UNCITRAL rules. We have a full-time staff of roughly 70 people. They are all experienced legal counsel whose expertise is investor state, and then a support team of paralegals, administrative officers, IT officers, and finance officers. And we have access to hearings internationally. So we are able to, if the parties want to, do the hearings anywhere in the world that they would like to do. And I heard you speaking earlier, Minister, about your new facilities. And it struck me that that might even be a good place for us to do some ICSID hearings, if that was interesting. So it's something I will follow up with you at a later date. If we can go to the next slide, I wanted to talk to you a little bit about ICSID as an international institution. It is one of the 5 institutions of the World Bank Group, and we have 155 contracting states, with Djibouti having been the most recent state to join ICSID. If we move to the next slide, the structure of ICSID really is twofold, fairly simple. On the next slide, you will see, if we can move to that, we have on one side what would be called the governance of ICSID, and that's the Administrative Council. So each member state has one vote, meaning the vote of Kazakhstan is equal to the vote of the United States and China and Togo and every other country. So it's one vote per state and one representative who sits on that council. And the key roles there are to approve rule amendments, to approve the annual budget, to select the Secretary General and deputies, and something very important, to designate persons to panels of arbitrators and conciliators. On the right-hand side, you will see perhaps what's mostly the operational aspect, and that is the group that actually administers the hearing in the Secretariat, and that is the staff of 70 people. And their key role is to be assigned to each case and to support the tribunal and the parties throughout the case. Then on top of that, we have obviously some training and technical assistance functions. And if we pass to the next slide, you will very quickly see the happy group who has not been at their office, of course, for about 14 months, but that is the ICSID staff who do this work. And if we go to the next slide, you will see basically our case administration. Typically there we have a 3-person panel with our tribunal secretary who sits with the panel to make sure that the matter goes smoothly. And that is our main role. On the next slide, I wanted to show you and get into a little bit about the increase in cases. And I know, and I have a number of slides later I can talk to about how obviously you have seen an increase in cases, but actually dealt with them commendably. This is a global phenomenon. What we have seen since the mid-1990s, obviously, is a very large increase in foreign investment. And at the same time, that line, the yellow line, shows that we have seen an increase in these international investment treaties all over the world. And most of them have the possibility of investor-state dispute settlement. So while there are a huge number of cases in the last, in particular, 20 years, it is very much reflective of the fact that there is a huge increase in cross-border investment and a huge increase in the number of these international investment treaties. So there is a logical context behind it. If we go then to the next slide, ICSID is able to help the adjudication of these cases in a number of respects. The most usual is the slide on the far left, cases under the ICSID Convention. And that is where an investor whose state is an ICSID member, one of the 155, has a dispute with another state, and they are also a member of ICSID. And there are 2 main options there: conciliation and arbitration. Conciliated, and in fact, history has shown us we have only had 13 conciliations, and most of the cases have been arbitration. So in a moment, I'll talk just quickly about what to expect at an arbitration. We also have a set of rules where if only the investor or only the state comes from an ICSID member state, then they can opt into a set of rules called the additional facility rules. And they too have conciliation and arbitration, but also something called fact-finding, which has not been used, but we have upgraded the fact-finding in our new amendment process. And we do think it's a dispute settlement tool that in very specific circumstances, it would be useful to states. Finally, we have a number of other dispute settlement roles. We are case administrator under a number of specific treaties, a number of state-to-state treaties. We are often asked by parties to be an appointing authority. And increasingly, and this is a theme I think you'll be dealing with, is we are seeing an interest in and efforts to do mediation. And in fact, we propose a new set of investor-state mediation rules, which may well be of interest to you in future cases. Finally, we act as the secretariat for EU regional trade agreements that include the investment function. So that's the basic work that ICSID does. I'd like to just quickly describe the classic steps in an arbitration so you know what to expect if you have not been a part of that. Essentially, the process starts with a request for arbitration where the investor says that they would like to start an arbitration at ICSID, and they have to put the basic facts forward. And we do a review of what they have submitted. And if it is manifestly outside the jurisdiction of the center, the case cannot even start. So it's seen as a bit of a screen for frivolous cases or cases that would clearly be outside of jurisdiction. If it's arguable that there's jurisdiction, we will register the case, and you will next go to selection of the tribunal. The norm in these treaties is to have a 3-person tribunal, and the most often seen formula is that each party is able to select their own arbitrator, and then the 2 parties will consensually agree on a presiding arbitrator. And ICSID is able to help the parties if they're unable to reach consensus on this. And if they still can't reach consensus, we are able to select somebody from the panel of arbitrators, which is why it's so important to have good qualified people on that panel. You were not allowed to have a national of either party as your arbitrator, again, trying to keep any kind of concerns about national bias out of this whole system. Once your tribunal's in place, you will go to what's known as a procedural meeting, which basically sets up the preliminary running rules, including where you're going to meet, when you're going to meet, certain procedural aspects of your case, and that will result in what's often called procedural order number 1. And you can think of that basically as the running rules for the arbitration. And then your next step would be to prepare and file your written materials. And as you know, arbitration is much more of a written process than many court systems. So you will have memorials that essentially set out the facts, that have affidavits or depositions with the evidence that will set out what you think is the appropriate law, and obviously explain to the tribunal why your view of the facts and law gets to a certain result. After that, you will get to a hearing where that information will be really focused on. And at the hearing, you will find that the tribunal really focuses on the areas that they think are not as clear or that are most in dispute. This whole process on average takes about 3.5 to 4 years. So parties need to be prepared for the long haul. In terms of cases and caseload trends, I just wanted to go through a number of slides, and I'm going to go through these quickly because I will provide you with the PowerPoint. But if I can go to the next one, to give you an idea, in the last year, ICSID concluded 68 of these arbitrations, 35 awards, which means the last decision in the process, were issued, 455 different decisions and procedural issues ordered along the way, and 165 sessions or hearings held. So it's a really busy place and a lot is going on. On the next slide, you will see something that very much mirrors what we saw earlier in terms of treaties, and this is the number of cases. We had an increase in the late 1990s, in particular with NAFTA cases and Argentina cases. That has continued to grow, and the new norm for ICSID is somewhere around 50 cases per year. So there has been a sort of stepped but progressive increase in cases in the last 25 years. And as I say, if you look to the next slide, you will see that we are on average administering about 300 cases at any one time. Interesting to note on the next slide where these cases come from by region. And from our statistics, we are seeing about 20% in Eastern Europe and Central Asia. And it will not surprise you to know that many of these are addressing oil, disputes that come up in the oil, hydrocarbons, and mining sector. South America has 32% of the disputes. Western Europe has 13% of the disputes, many of those arising recently under the Energy Charter Treaty, Middle East with 10%. So you can see roughly how the disputes are distributed among countries. If we can also go to the next slide, and this will give you an idea about what economic sectors are involved in these disputes. Not surprisingly, 30% in gas, oil, and mining, and 20% in electric power. I think probably because these are long-term projects, long-term contracts. They are often projects where you have joint ventures of different nationalities, and they are projects where literally you have a lot of cost in the ground. So it's not as easy if something falls apart to just simply walk away. And so this is year on, year out, where we see the largest number of cases. and I'm sure has some symbolism for Kazakhstan as well. I'd also like to talk to case outcomes. If we can go to the next slide. It is well known, and again, a highly consistent statistic, that the awards are upheld in about 31% of the cases. And that means upheld usually in part, but sometimes in full. In 34% of the cases, all claims are dismissed. So in 34% of the cases, the states are fully successful. And a most interesting statistic, in about 35% of the cases, the claim is settled or discontinued before the award. And this means that there is a lot of room where you think it would be better to settle. There appears to be a lot of room and a lot of willingness to do so. And we've seen countries getting more and more creative about the terms upon which they settle. And I think this is a recognition that the whole idea here is to get the investor into your jurisdiction, operating and maybe even expanding their operations, and that sometimes a good settlement is much better even than a good arbitration. And that's something governments increasingly are educating themselves on these days. And I think we're going to see more of that. If I can go to the next one, Kazakhstan, of course, has been a member of ICSID since 1992 when it signed, and it came into force in October of 2000. And the members from Kazakhstan who are on our administrative council are His Excellency Dalanov from the Ministry of National Economy and His Excellency Irgaliev from the Minister of National Economy as well. So those are the people who would be casting votes on behalf of Kazakhstan, for example, in our next amendment process. There are several pending cases. If we go to the next slide, right now at ICSID, you have 3 pending cases. 2 are original processes, and 1 is an annulment. If we go to the next slide, we have a list of the past cases that have all concluded. And you will see that in some of them, the claims were upheld in part, some of them were discontinued, and in others, the claims were rejected. Interestingly, and in all of this, we know that investment is a two-way thing. If we go to the next slide, you will see that there have also been at least 4 ICSID cases where Kazakh investors have been the persons commencing the arbitration against another country. So it is very much a two-way street, as all of these bilateral treaties are. Just to pass to the next one, I have a slide that I think is kind of interesting, which shows cases and the number of cases per country. And as you will see, well, I think you may feel that you have had a lot of cases. You will see that there are others who have way more cases than you have had. And Kazakhstan has had total, both ICSID and non-ICSID, 19 cases to date. The nice part, I think, is the next slide, which shows the outcomes of your cases. And this very much mirrors the general outcomes we've seen in investor state, where 10 were won by Kazakhstan, 2 settled before the award was rendered, 6 were lost, 1 is currently contesting enforcement, and 4 are pending. So that's a very sort of, I think, balanced set of outcomes, which is a good thing to know. In terms of sectors, which I'll just go through quickly, again, obviously, you know this better than I, very much cases are in the oil, gas, mining, and electric power. If we go to the next slide, we will see that. So 50% essentially is in those 2 big sectors. And what that probably tells you is that's an area where, as you do your legal reforms and as you give publicity to the fact that you are becoming an ever increasing good jurisdiction to be investing in, it's those 2 sectors where you might really want to focus some of your efforts, because they're the ones that seem to be bringing up the most cases. Next slide, I will just go quickly, which is the breakdown of cases in Eastern Europe. And we have seen, as you can see, a number of cases in Eastern Europe. So to conclude the pieces on cases, what I would like to say is that number one important thing is to be able to prevent those cases you can prevent. And we have a number of materials on this, and it's something we would be happy to speak with government officials about separately. But there are a number of ways to try and identify problems that are starting early and take prevention measures. Also important that your individual officers dealing with this are aware of this possibility. The second part is being well prepared for your litigation. And the third, I think, is communicating this. And then just finally, I wanted to let you know that we are in the middle of a most comprehensive rules project. If we can go to the next slide. And we have had great support from the Kazakhstan officials who've been a part of this negotiation. If you go to the next slide, you'll see some of the bigger, more controversial issues, things like security for costs and third-party funding. We expect we will be voting in the next 6 to 12 months to approve these rules. And so we will be speaking further with the Kazakh officials about this. And then finally, of course, as Professor Berman noted, we're working with UNCITRAL to help draft an overall code of conduct for arbitrators. So that's a lot of material, but I hope that it gives you a picture of the overall sense of what's happening. And the one last thing I would love to refer you to on our website is we have a number of very useful materials, but one in particular is called Guidelines for Respondent States and gives a lot of good ideas about the ways government can organize itself in-house to try and identify problems early and resolve them. So that's a quick overview of ICSID. Thank you.
Well, thank you, Meg. That was